I can tell you what my ruling is going to be. What my ruling is going to be is yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. All right, are you all ready to go on the record?
Yes, ma'am.
All right, the court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Amy Owen for the defense.
All right. And the other two attorneys who are here?
Yes, Judge. Brandon Wong for Alexander.
A Texas courtroom turns tense after defense attorneys demand private medical records connected to a child abuse case. The defense says the child's mother suffered a brain injury years earlier and believes her medical records could contain information that may help the accused. The mother's attorneys fight back hard, calling it harassment and a fishing expedition into deeply personal medical history. Now Judge Stephanie Boyd must decide whether those private records could change the entire case or if they should stay sealed forever.
Reed.
All right, so everybody, please do not whisper because the court reporter cannot hear. So,
Brandon Wong for Alexandra Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other two attorneys being present, I want to make sure that you have all the discovery from the state that the state has in its possession.
That the state has in its possession, I believe so, Your Honor. I do not know if that's what is in their possession is comprehensive of the order of the court of what was ordered to be turned over. I had not looked at that yet, since we do have a final discovery, I believe, setting, I think it's on the 24th.
It's the 24th.
So this was set for the motion to quash today, and we already have a discovery setting set on the 24th.
Okay. All right. So let's go over the motion then. And I have a first amended motion.
Yes, Judge. Do you need a copy?
Oh, I have this. And did you file a motion as well, or is
I
this?
did not, Your Honor. I found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your Honor,
So defense.
Your Honor, so as the court's aware, we have sort of argued this prior to the court, and we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2022 up through January 31st of 2022.
All right. Do y'all want to write this down, what she's asking for?
I can get it.
Okay.
Let Mr. Wong know. So there's American Health Imaging on January 6th, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records, mother's outcry witness in this case. And we believe that what is contained within those records could be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
All right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Judge, obviously, they're asking for my client's protected HIPAA information. It's just clearly a fishing expedition. The subpoena is defective on its face. They actually didn't even follow the procedure. They didn't serve my client. They never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know,
Obviously, I know about it, but and
'Cause
that's
you're
why we're
here.
here. But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
but this is the person that the state is calling as an outcry.
I get it, Judge. But again, she's not the only one. And then they're still able to have my client on the stand, ask her whatever they want. You know, that is, we all know that is how it works. And so they're able to get whatever information. They're trying to link something that happened 10 years ago and saying, well, now she got some sort of mental handicap where she is now convincing her child. And, you know, that's their strategy. It's not even a secret. They're trying to say that she has influenced her child to say that these allegations have occurred to her. It's a stretch to say the least, Your Honor. And so again, it's just harassment on the part of, you know, they're just making my client spend countless dollars and time fighting this thing. She has nothing to do with it. All she did, she made a report and that's it. She's out of it. And so again, for them to now see all of her records, you know, now they're cutting it down. Originally it was her entire medical file, her entire medical records. And I understand they just want a couple visits here and there. But again, Your Honor, my client's still going to have to produce them. It's a hassle. There is nothing relevant that's going to come from this. And they're keeping it's possibly exculpatory. They don't know. There's nothing other than just their speculation. It's just pure speculation that they can come up here and say, you know, we just want to harass this lady to get these records just so we might be able to strengthen our defense. And again, as the prosecution has said, it's just not relevant.
Okay. And do you have an argument?
Your Honor, we just merely support the patient, Dr. Rodriguez's patient, Ms. Reed. It's her record. She doesn't want to produce them. We don't want to produce them. And it sounds like from the summary that was given by defense counsel, they're not even asking for Dr. Rodriguez's records at this point. Is that correct? Even though it's okay, so we have a subpoena, but you know, so we need protection from that subpoena. I can file a separate motion, or
Well,
we
I
can
mean,
agree on the record today that it's, or as the court determines, that
well,
subpoena is
just one
withdrawn.
second, because I'd like to
Oh, yes,
cut to
yes,
the
Your Honor.
point.
Okay.
So this attorney, his patient, or his doctor,
Yes, Your Honor.
are there any records that you want from this doctor?
I don't believe so, Your Honor. However, since we don't have any, we don't know if it references, you know, any type of diagnosis or treatment that's referred back to that. But these specifically what I read are what we're requesting.
All right. So here's the thing. Number one, he's saying that the subpoena is improper on its face because it doesn't have the correct name, the correct date of birth. I think we all know who it is and who we're here for. If you want to make another trip down to the courthouse and they can correct the name and the date of birth, they can do that. But I can tell you what my ruling is going to be. What my ruling is going to be is yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. And my understanding from both sides, or let me make it clear to everybody, that's the specific thing. We're not going outside of that specific thing. So counsel, if there is something that you feel that the attorney who's here today, that there's something that they have, let them know specifically what it is. And then if you all will present it to the court, not to the state, not to the defense, just present it to me, I will review it. And then I will make a determination whether it's relevant or not. And my understanding from defense, they're no longer asking for the entirety of the record, which I would think the entirety of the record would not be relevant. But the specific part she's asking for, I'll review them and make a decision on that. So first question, are you going to want me to rule that on its face because it has the wrong date of birth, wrong name? And just
On its
say,
face, Judge, honestly, yes, Your Honor, they need to refile it.
all right, so
And then I'll
this is-
ask my client, once they serve a proper subpoena to provide said documents and then, because I understand what your ruling is, but
Mhm.
obviously I can't agree to release her records when it's just not been properly done.
all right, so when will you have your subpoena ready?
Today.
All right, so she's gonna have her subpoena ready today. So while she's getting her subpoena ready, if y'all can get those records ready for the time frame, if you give them the time frame, it's not, I read very quickly. It's not gonna take me long to do it and to review everything.
And Your Honor, I think the other issue would be that in order to for anybody to get the records, that the court would need to order Mr. Wong's client to sign a HIPAA release to the actual entities to be able to release the records to the court.
I'm not gonna order her to sign a HIPAA release,
Okay,
so.
so once we get the subpoena and then the court, we would direct the entity to send the records directly to the court.
Yes,
Okay,
and then if you all are able to get the records directly to make the process move quicker and bring them to me, and I will review them in camera. And as I said before, when I review things in camera, I really review them in camera. Defense doesn't see it, state doesn't see it, her client's not going to see it. I'll be the only person who's seeing it.
May I address?
Sure.
Your Honor, pursuant to HIPAA and the CFRs underneath that, we have, if it's a third-party subpoena, to be able to release the records, we need to be ordered to produce those records. And then there needs to be provisions that they're prohibited from using the records and disclosing them outside the litigation, and they're required to return the records upon the conclusion of the proceedings. So
Here's my thing.
may I pass something up to the?
Sure. But you may pass it.
Yeah.
Is if you all will confer on the date she's speaking about,
Yes.
and then she can have her new subpoena and you all just get the records prepared for the court. And if you all can have the records and bring them to me, because sometimes when things are mailed to the court, it goes to 6 different places. People don't read 187 4th floor with a suite number. So it goes to different places. And so nobody else will read it, just me. If y'all will bring it to me, and if you could put it in a sealed envelope that says judge only on it, nobody else will open it. The staff would not open it. It'll go specifically to me.
And can we go ahead and submit an agreed order on how those records are being tendered up to you, because you've directed us to do it?
Sure.
And
If you all
put it
can,
with the documents?
yes.
Okay, you okay
Yes.
with that?
yeah, sounds
Okay.
great.
All right. And then she'll get the subpoena. But I will tell you, our next court date in this court for discovery matters are August 24th.
Yes.
So if you all can have all those records to me before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay,
All right. So August 24th, does anybody need anything else?
No, Your Honor.
no, Your
All
Honor.
right. And if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom, as long as I have the records to review in camera. Is there going to be any objection?
No, ma'am.
All right. So if you all would like to appear by Zoom, just let the court know. The court coordinator will give you the Zoom link.
That'll work. Thank you, Judge.
All right.
Good.
Thank you.
This hearing was not about proving guilt or innocence yet. It was about one major question: should deeply private medical records become part of a criminal case? The defense argued they were only asking for a small group of records connected to the weeks before the child's outcry. They believed those records could contain important information that might help explain what happened. But the mother's attorneys strongly pushed back. They said the defense was trying to dig through years of private medical history without real proof that anything useful was there. Judge Stephanie Boyd tried to balance both sides carefully. She did not immediately give the records to the defense. Instead, she decided she alone would privately review the records first to decide if anything inside was truly relevant to the case. The moment showed how complicated criminal cases can become when privacy, medical history, and serious allegations all collide in the same courtroom. Do you think the defense should have access to private medical records if they believe it could help the case? Or should personal medical history stay protected unless there is very strong proof it is directly connected to the allegations?